The order allowing account. Hi, I'm Darren Findling of the Probate Pro, and we're going to examine the scale form, State Court Administrative Order, form PC 585B. This form can be readily obtained through an internet search, or you're welcome to call my office. We'd be happy to give you one free of charge. As you can understand just by the title of the document, the order is the ruling of the court. So of course the court speaks through its order. So this order would be used after a petition has been filed requesting the allowance of an account. And I've covered that particular form in a separate video. So think of it like this. You file a petition, it gets filed, scheduled for hearing, there's an adjudication, and then an order gets entered. So this is the back end. This is the final aspect of the accounting process. Now, with all of the scale forms, the relevant statutes and court rules are generally provided in the bottom right corner. As you can see from the floating yellow arrow, I've highlighted the area so that you can identify the relevant statutes or court rules that are applicable to this particular filing. Now, an accounting can be done in a variety of contexts. So, of course, in the deceased probate estate, there may be a requirement to account. Within trust administration that's being supervised through the probate court, there could be a requirement to account, as well as, of course, within a conservatorship context, and sometimes even in a guardianship context. So this form and the statutes that are related in the bottom right corner apply to the various accounting requirements that are set forth under Michigan's probate statutes and court rules. So a very versatile form that's used to identify the court's ruling after an account has been requested to be allowed through a petition. So let's work our way through how you complete this form in preparation of the court hearing that will be occurring. And sometimes the courts will ask that the order be supplied and provided under the court rules in advance of the hearing. So you'd file your petition and submit your proposed order. Some courts aren't quite as strict, and they'll just simply need you to have that order allowing account ready for the hearing. But we typically want them prepared and provided in advance with the petition itself, the proposed order that we're seeking to enter, to be in compliance with the court rules. Now, with all of these types of proceedings within probate court, and anytime you're using a scale form or any matter through the probate court, we strongly urge you to be working with a skilled, competent, experienced probate practitioner to understand the statutes, the court rules, the language that's being spoken within the probate court. So let's work our way through the document. Top left corner is the county in which the probate matter is proceeding. Top right corner is the case number. Now, if you notice at the top, it says order allowing accounts, and there's a parenthesis around the letter S. And what that means is that there are times that you may be using one order for multiple accounts. So, for example, if you're asking the court to approve the first and final account or first and second account, then it would be multiple accounts. So you don't need a separate order for each petition or account that's being sought for relief. Top part is in the matter of, that's simply the estate name, the date of the hearing, and the judge. Pretty intuitive there what to be putting in. The name is the person that is filing the petition. So generally, let's pretend you're the conservator. You put the name of the conservator. The title is the fiduciary role upon which you are seeking the court to allow the account. And it identifies who the person is and their fiduciary role, and that you file the petition within court asking or requesting allowance of the. Now here you can see in the small print it says, is it an interim account, first, final, second, third, etc. You'd identify that language there. Pretty easy to fill out. That's the top part. As you move further down the document, this is simply what the court has ordered. Now, there's a risk of filling this out in advance of the hearing, because if you check certain things and say that the court has allowed the account and then the court has different findings, then you may have to do a little tweaking of the document. But these are the findings of the court as it relates to the hearing. Number 3 says that notice has been provided. Now remember, the noticing requirements under MCR 5.125, as well as the relevant statutes and court rule, provide that on any petition, you have to give notice to the interested persons in that particular proceeding. So in this case, on a petition to allow an account. That would include the individual upon which you are seeking protection over. Maybe it's a protected individual. In a deceased estate, the interested persons are different than, of course, in a conservatorship. So you really have to understand how to give good notice, because one of the most frustrating things for anybody is to file the petition, do all this work, get it scheduled for hearing, wait for the hearing date, only to learn when you get to the court hearing that you failed to give the requisite notice. The court adjourns it, schedules it out weeks or maybe even months later. Very frustrating. So make sure that you've given notice correctly under the statute and court rules to all of the interested persons as defined. Number 4 provides that there's a finding that the account or accounts are correct and ought to be allowed. And 5, if there's any fees being requested of the fiduciary. So for example, if the personal representative or conservator is seeking their own fees, as well as any attorney fees or costs, those are set forth there. And then any exceptions would be handwritten or typed in there to identify whether there's a reduction by the court as to any of the allowance of the fees or costs that are being sought. The next section is the order. So everything above is the findings. The next section is what has the court entered? What does the order provide? Again, it's very repetitious here. 6 is you check the box for the number of the account. I'm not exactly sure why there's even a checkbox there, because if you're seeking the allowance, I guess if your order was not allowed, you may not check it, but it seems a little odd there. Number 7, again, the fees and costs of the fiduciary and the attorney fees. And then 8 provides that, for example, in a conservatorship context, if the conservatorship is over, if it's a final account, you may be releasing the remaining money to the guardian or the personal representative. And then B provides for the transfer. So a receipt would be necessary to show that the conservator has turned over the money to the party that is entitled to receive it. And then, of course, if there's a surety bond, that surety bond can be canceled to allow for the discharge of the bond, release of the bond, and discharge of the fiduciary. Number 9 provides for the fiduciary's discharge, and that is a release of liability. It's an important piece of the request. If it's a final account of a conservator or personal representative, you want to be discharged, released of liability, and the bond canceled. Another checkbox for that. And then 10 is quite simple. Is the file need to remain open for continued jurisdiction, or is it all over, and should the file be closed? So again, these little checkboxes there are really important to understand, because if you go through and you get a final account and you don't click that you're discharged, then you'd have to go and seek an order of discharge later on. So you really want to make sure that you complete the order correctly so that when the judge signs it, it fully encompasses all the rulings of the court and releases you of your liability. At the Probate Pro, we are passionate about everything probate. If you have a question about the order allowing account or any probate or trust related issue, visit us at theprobatepro.com or call us at 1-833-PROBATE.